life water comes in a, I just need to start drinking more of it. Okay. What are we doing here today? I have no, yeah, what are we doing? Yeah, weather.
I'd like to welcome everybody to the regular scheduled board meeting for February the 25th. If you have any electronic devices, cell phones, etc., if you will, mute them for us. Ms. Sarah, would
Yes,
you
sir.
lead us an invocation and pledge?
Dear Heavenly Father, we thank you for the opportunity to be here today and conduct the business of the great people of Walton County. We want to reflect also today and ask your grace on those who have lost loved ones recently. Former Commissioner Van S. Butler, we pray for his family and that you will give them peace. And former Commissioner Randall Envinger, will you give his family peace during the coming days as they suffer the loss of his son. We pray for others as well, Lord, that may be suffering an injustice or an injury or a death in their family. We pray that you will give them the peace that only you can give. We ask it that you guide and direct us in everything we do. In Jesus' name, amen.
Amen.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Before we get started with our regular agenda, I want to take this opportunity to acknowledge one of our longtime employees, Assistant County Administrator Stan Sunday has reached his 25-year milestone with law enforcement and the Department of Corrections. I remember Stan in 1989 when we hired him to work at the Sheriff's Office. I tagged him right from the start with a nickname. Now, he may not want this known, but everybody's going to know about it. I called him Rooster because he's like a Benny Rooster. However, Stan did a good job under Sheriff McMillan. He subsequently went to work for Sheriff Johnson and then subsequently to the county as director of the county jail. And now he's in a different capacity, one I'm not sure he wanted to take. He's probably learning that. However, I want to present him with a plaque. If you will come forward and stand down there.
Why are you limping? Thanks.
Okay, I believe what we got is we got some additions and deletions from the agenda.
Yes, sir. Give me just one moment, if
Okay.
you would. Thank you, Mr. Chairman. Under deletions, the Nigerian legislators were unable to be here today.
Correct.
So we will hopefully entertain them at a later date.
They will be coming back.
Okay.
No, not today.
Under the consent agenda, we're going to ask item 4 to be removed and added under admin for discussion. And then under Public Works, item 2B, we're going to ask that be removed from the agenda, that we get some clarification on some issues regarding that right-of-way agreement.
Okay.
So those are the changes that we have.
Motion to approve the deletions and additions.
Got a motion and a second. All in favor, say aye.
Aye.
Motion carries. Okay, we're at the consent agenda.
Motion to approve.
Second.
Got a motion and a second. All in favor, say aye.
Aye.
Motion carries. Is there any public comments concerning any agenda item from the public? Come forward, please. Can you state your name for the record?
My name is Mary Nielsen, and my first question that I'd like an explanation for is why the public comments have been moved to this section of the agenda, and why are we no longer able to discuss each item as they're being discussed or voted upon. We have public comments now in the beginning, then we have public comments at the end. This was tried a few years ago. Some of the public disagreed with that. It was changed, and now it's back in the beginning.
Well, normally what we've done here recently, even though the public comments is at the front and at the rear, if there's a particular topic and somebody raises their hand, we have allowed them to come forward and make their comments.
Okay. May I make a comment when you come to the Brigman contract, or must I make it now?
If you care to make it now, fine.
I'd like to make it now. As a realtor and someone interested in our finances, the county's finances, as I understand it, when Love's purchased their property, it was for $33,300 an acre. Then you entered into a second agreement with another entity for $20,000 an acre. Then Brigman offered $15,000 an acre. Now they're up to $20,000 an acre as attached to this agenda today. But the average of the two would be $26,650. So I don't know what your intent is, and I know that a few of you have been noted on the record to say that what's most important to you are jobs. I think that if you were offered half of what your house is valued at, what you wanted your house to be sold at, you wouldn't be lowering your price when there's an established market price. I can't believe any one of you would take an offer, $15,000 an acre, even $20,000 an acre, if you already had a sale next door at $33,300. So I really would like you to do a counter. And in that counter, I think you should bring that price up. It is what it is. That land is there. The infrastructure is coming there. It's going to be an asset to our county, and I don't see why you should be selling it out. The next topic, and I don't think you should be paying commission unless that's agreed upon in early on, and you have a set policy about commission. Since I've got 2 minutes and 28 seconds, I'd like to go to the third thing, civil citation resolution. Do you have a study, and do you have any statistics that show how many civil citations have been done in the past 12 months, what they're for by category, how much money has been levied, and how much money has been collected? Because if you want to affect change and behavioral change in people, the first one, a $50 one, is like a joke in some of these categories. So I think that you've got some fees that you should have statistics to back up your fees. Do you know how much? How much do we collect? How much do we cite? That we never ever collect, that gets written off, that never gets collected. And we have the same behavior over and over again. You've got category 1, category 2, and category 3, $50, $100, $200, whatever the matter may be. So I think that you need to start off with a little bit of teeth if you want to affect change. When people understand they can't do something, it's going to cost them a bunch of money, and I'm one of them. I'm not going to speed down Highway 98 because I know now how much it costs. And you do too. And it's a lot of money nowadays. It's not $50 when I went over the limit in the old days. Coming down from Alabama, it used to get a little bit higher, but now it's really up there. So no, I can't take my foot off the pedal. And I think that you should apply that principle to some of these civil citation fees, and I would like you to have some statistics to back up why you've got them at $50, some of these things, and $100 and $200. Because it's just the cost of doing business for some people. And they don't give a flip. So I have serious issues with the Brigman contract. I'd like to see that whole philosophy of lowering your prices rather than using market values. And I think that you need a policy about real estate commissions, whether they come in on the front end, the back end, who they're shared by, who's representing whom, et cetera. And if you haven't done them in the past, I don't see why you need to start doing them now. Thank you.
Thank you. Any other comments? Seeing none, Mr. Jones.
Thank you, Mr. Chairman. The first item under administration is the offer from Mr. Brigman regarding the Mossy Head Industrial Park. What you have in your packet is an offer that, if you recall at the last meeting, we had some discussion about this facility and their offer. We were asked to follow up with them. We did that. They increased their offer to $20,000 an acre, less a 6% commission. And I spoke with their realtor and told them I didn't think the flavor of the board was inclined to pay a commission. If they would submit an offer absent the county paying commission, which they did, at $18,800 an acre. So that is the current offer they're presenting. Is for a 10-acre parcel, which is depicted on the screen in front of you. The parcel to my right, which says 10 acres, and then the additional part that's not green is the property that we've agreed to sell to Empire Trucks for 20,000 acre. To that end, the chairman and I took a road trip to Birmingham to look at their facility, and there's some photographs here of what we found there. And as we go through, we had a lengthy discussion with Mr. Brigman regarding what we wanted to see in Mossy Head and what we would expect to see, and he has provided us with two renditions of what he would visualize the facility there to look like. We don't have any commitment as to exactly what that would be. So your options today are to accept their offer, to counter their offer. We would like to see more detailed information as to what exactly their facility is going to look like before we get too far down the path to approving anything.
Okay, Mr. Chairman?
Yes, go ahead.
And I also agree. I think at a minimum $20,000 an acre. I know that Love paid premium price for that. Of course, it is the premium piece of property. On the other side of that, now that Love's is there, it is a huge attraction to people wanting to be in that park. I mean, it's a plus to be anywhere where Love's is. So I just cannot see taking any less than $20,000 an acre. I am not in favor of paying a commission. That should be between the person that's buying it and the realtor. It shouldn't come off the county side. And I, too, as well, I saw the pictures that you sent us, and, you know, it looked like a nice facility. But there again, we want that park to be above nice. We want it to be great. For that reason, I'm not comfortable till we see definite, this is how it's going to look, not this how it may look plans.
I have a question, too. You said that $18,000 an acre. The one I have says 10 acres and $200,000.
Yes, ma'am. That $18,800 an acre is our latest offer, which is if you in that $20,000 offer, there's a 6% sales commission they're asking the county to pay.
Oh,
so
okay.
It
So
actually nets down to $18,800 an acre as well.
That explains. Okay.
Mr. Mayfield?
Okay.
I've got the same one that Commissioner Meadows has, which is at the $20,000 an acre. And I don't see anything in here with regards to their commitment on the infrastructure and the timing for the completion. So the net effect is, you've just said, instead of $20,000 and a 6% commission, we'll subtract the 6% commission from the front and make it 18.8. So it's, in effect, the commission's still in there.
Commission's still in there.
Commission's still in there.
Are we still in negotiation with Empire?
Yes, sir.
You know, I think we need to deal with Empire and work with Empire and see what their needs are going to be. If you know, or if they said they need this parcel of property that the Bingham's trying to obtain, or Empire.
We have had some discussions with Empire as late as Friday of last week. We do not have a proposal from them. So at this point, it's no more than discussion.
What does it cost us to clear sites and haul off the debris?
Probably between $2,000 to $3,000 an acre, and maybe a little less if we can burn it, but somewhere in that neighborhood. Is that fair, Wilmer?
On those cases, are we using our crews?
Yes, sir.
So we're already paying them whether they're at place X or whether they're there, so it's not an additional out-of-pocket cost.
Right.
It's just redeploying.
But it does
existing-
take them away from something else that they were working on.
Possibly. My understanding is that when there are days of inclement weather that they can't work on roads, they could be doing stuff like taking the trees down there. And I saw them when they burned the stuff from Love. So I think there's some equity from the county standpoint that could be utilized, especially during days of inclement weather, to essentially be the cost of fuel is what our cost would be to the clearing.
Right.
Well, since there's some discussion still taking place with Empire and the county, I was wondering if the Brigmans would be adverse to looking at the far west side of that particular area and putting their structure in there.
Which, like what's depicted as Lot 1?
Lot 1, yes. Mr. Brigman or Steve?
Hello, everyone. I'm Steve Ewell with Andrews and Arnsdorf.
Brian Brigman.
Are you talking about Lot 1 from the,
Yes, Lot 1 that's on the screen.
Is it my understanding that Empire's wanting more than the 15 they were talking about? Or?
We have had some discussions with them. They've not made an offer, so I'm not really not in a position to say exactly what they want because they've not laid it out to us.
Right. I mean, they started out with 10, then they went to 15, and now they might want more. I'm just asking.
Yeah, right. That's
I think it may make sense if we possibly accept Lot 1. However, if Empire comes back at 15 acres instead of 20, to shift your property to the east and take the 10 acres next to their 15.
Okay.
That makes business sense to me.
Yeah, I just wanted to try to get next to them. If all this is going to be cleared off, then we, be next to each other instead of having a lot that's empty.
so. If I understand, you're willing to let us work with Empire and see exactly what they're looking for to do, and if what is depicted as Lot 1 would abut what their additional needs may be, that you would be inclined to look at that favorably?
I'm not hard to work with.
Okay. And I do want to say to Mr. Brigman, he was, very kind and generous in trying to share his trip there. We kind of surprised him because they didn't know we were coming, and but was a very gracious host and allowed us full access to their facility. So.
But I think it's very important for us to, if Empire was the first on the, first pick, we need to work with them and make sure their needs are met, because what they need, their needs are. Because after you make the decision on who gets what, if they come back and negotiate, say we need 5 more acres or 3 more acres, whatever, to do what we need to do here.
Well, from our perspective, we're certainly willing to work with the Empire folks and Steve and Mr.
Yeah,
Brigman
yeah.
and keep them abreast of what it's all looking like, and then kind of build that whole area so it's in everyone's best interest.
Today, can we at least come to a meeting of the minds on the other terms of the offer and have the contingencies on which land it is?
A bit.
Well,
I think it's hard. Would be hard to do here today.
I'm almost of the opinion maybe since we've still got some outstanding discussions with Empire, we're not really sure what their needs are, as Commissioner Pridgeon alluded to.
Yeah.
To keep this thing from going on and on and on and on, why not we just set some type of timeline for Empire to decide what they want to do? Let us know if it means a week, 2 weeks, whatever it may be, so it doesn't keep Mr. Brigman and Steve and them in limbo exactly what they're looking at.
We'll be able to be glad to convey that to the folks at Empire.
For our next board meeting, perhaps?
Certainly. We can let them know we need a
Everybody?
definitive decision. Okay?
Okay.
And then we'll be in touch and let you guys know, and we'll share those things with you, and we'll move forward. That work?
He's ready to get it open.
Okay.
Okay, thank you very much.
Thank you.
Thank you. So just to be sure I'm clear, we'll reach out to the Empire folks and follow up on the discussions we had with them last week and make it clear that we need to know what their intentions are in time to have it at the next board meeting.
Are we going to make we're going to have any discussion or any decision on the price of the land, that we're going to, not go below 20, or how are we going to do that? Just
What I've heard from the board is I think 20,000 is the minimum, anybody. I don't agree, like I think Ms. Sarah, as far as us paying a commission. Sorry, Mr. Ewell, I just don't agree with that. He's your client, not ours, per se. You don't represent us, you represent him. And I think those are things that should be afforded to the buyer. That's his responsibility. That's just my opinion. I think it's Sarah's opinion. I'm not sure.
There's three of us.
Yeah.
Well, there's three of us that feel that way.
I feel that way
So,
too.
4,
4.
5.
Yeah, we all feel that way.
4.5.
Is that an official vote?
Okay,
4.5.
but I think you can see that this, I'm not in agreement. I think the majority of the board is not in agreement either with paying the commission to the realtor.
And Commissioners, just so we're clear too, this is offer and acceptance has to be contingent on the county's compliance with Section 125 of the Florida statutes.
Right.
my question is, let's say a broker from Atlanta had a client and he was looking at 3 or 4 different sites, and he wanted a commission, and would we pay it? And it was a really good client, and we wanted him, and he said, well, here's the deal, commission, this, and this, maybe 3% instead of 6 or whatever. Would we entertain that?
Yeah, I would suggest we be careful setting any hard, fast determinations for that very reason. Granted, I think
That would be my only
Yeah,
thing about it. I mean,
yeah.
we may at one point, somebody may say, hey, we're going to bring,
And-
Microsoft in here.
Yeah,
but
and I don't disagree with your other position as well. I think
Why don't we
as
say
a
at this
rule-
point in time?
Yeah, I
Is that-
think as a rule,
at this point in time?
those things are fine.
Okay.
But,
Okay, I just wondered, if that happened, could we, is there flexibility in that? Okay.
Okay. Any other questions? Comments? Mr. Jewell?
we'll be in touch, guys. Thank you.
Thank you. Moving right along.
Thank you, Mr. Chairman. The next item on the agenda is, for your consideration, is a proposal from Love's Travel Stores. As we're all aware, they have began their construction of their new facility in Mossy Head. What you have today is an offer from Love's to purchase 7 additional acres. As you'll see on the screen, to the left of the screen is Highway 285. The roadway you see is the service road that Love's is just to the south of. They're looking to purchase 7 acres north of that service road at $20,000 an acre to locate a hotel, which they are showing as a sleep in, and a restaurant, which they're working. Their initial idea is to locate an IHOP there. They've done that in a couple locations. They're still working out some details, but something along that line, a sit-down restaurant at that facility. So it's our recommendation that we accept their offer to move forward with this deal.
Their offer is $20,000 an acre.
Yes, ma'am.
And no commission.
No commission.
Motion to approve.
Hold on a second.
Yeah.
The motion has to be to approve contingent upon the county's compliance with Chapter 125.
Motion to approve contingent upon the county's compliance with that chapter.
Thank you.
Got a motion and a second. All in favor, say aye. Aye. Motion carries.
And just as an update, we also have some very strong interest from another group that actually sent us a proposal for a 60-acre tract that it didn't meet any of the things that we've talked about earlier. So if you understand, we're still working with them, and we hope if we can get to some resolution of what's a good deal on behalf of the county, we'll be bringing that to you in the near future.
You know, it's interesting. I don't think I ever noticed a Love's truck before, and now they're everywhere.
Everywhere.
I guess you notice now. I see Love trucks everywhere, and it's like,
Do we allow RV parks in this industrial park?
That is an allowable use. You know, and to that end, Commissioners, it was interesting as I and the chairman were driving to Birmingham, get off the interstate to go to the Brigman's project. There's a Love's there having a grand opening. So we got to see that. A very nice facility, by the way. So
Very
it
nice.
was very exciting. Mr. Chairman, the next item is the quarterly report from the Walton County Economic Development Alliance. That report has been provided to you in your packet. Mr. Yeager's here if you have any questions.
Y'all have any questions?
not at this time.
Seeing none?
Okay. You need a motion to approve that report? Yeah.
So moved.
Second.
Motion and second. All in favor, say aye. Aye. Motion carries.
And that we're going to have a website one day?
One day.
Yes.
Okay. Do we have a
Open
deadline
up,
for
Mr.
that?
Yeager.
Because I'd like to see a website by a certain date, or,
Yes.
I'm going to be severely disappointed.
I understand.
Amen.
Mr. Yeager, come on forward.
Preach on, sister.
Mr. Chairman and Commissioners, I anticipated that question, and I think it's a very appropriate question. As EDA Director, I take full responsibility for the lengthy delay in launching our new website. There have been some technical issues with the new content management system and an unexpected need to shift our domain hosting from one firm to another, but frankly, much of this time lapse could have been prevented had I asked for more help and assistance from others that were available to me earlier on. In light of all this, I'm a little skittish about committing to the exact date when the new site will be up, but I expect it will be no later than next week. We expect a period of downtime when the DNS servers are transferring from the old to the new. That could be up to 24 hours, and during those 24 hours, our site will not be accessible, and our email system will be down as well. That is what I anticipate, and I sincerely express my regret for the delay experienced here. And I take responsibility for it.
Any further questions?
I understand kudos are in order to Rick Wilson, who actually took it down and worked on it. Thank you, Rick. Yeah.
Anything else? Thank you, Mr. Yeager. Mr. Jones?
Did y'all vote to approve?
Did we vote to approve that? Yeah. Yeah, we did.
Okay, good. The next item, Mr. Chairman, is a request from the Howard Group to allow Walton County staff to assist in applying for grants relating to the Eastern County Road 38 US 98 corridor beautification project. We've had a couple of meetings with the folks that are working on this project. We have stressed to them the importance of identifying a source of funding, not just for the construction, but also for the maintenance of these projects. The request is from Lee Moore with the Howard Group, who's working with these folks, and simply to allow our staff to assist them in the preparation of any grants that they may find that would be appropriate for that project. We were clear that without expressed and explicit board direction, the county will not be the recipient of the grant. We will not be the applicant. It's simply to allow our staff to kind of guide them through the processes as they find these grants that they wish to apply for. So.
And one thing being said, the medians, along, where Sewer Sands and all's located are beautiful medians. But the county, we have got to get out of the business of maintaining those medians. So is that going to be part, we just can't continue to.
Absolutely not part of this.
Okay.
We're very clear that absent, clear direction from the board, we're not going to be the applicant. We're not going to be participating in the grants other than to provide technical support to the group as they move the process forward.
Any other questions?
Ms. Moore, is that your understanding? Okay, she's nodding, so just
I
I
don't
think
see
we're
her.
all clear.
You want to speak to it, Ms. Moore? I think you've met with all the board, haven't you? Okay.
Yeah.
She's not met with
That
me,
met
and
with
it's
me.
and it's in my district. I couldn't attend the first meeting, but I've
Would you
not.
like a brief thing?
No,
Okay.
I think the, medians are beautiful. I think people that drive by see, what an asset they are to the county, but we just can't afford to keep on keeping them up.
And we've been very clear with that in our
I
meetings.
think it's important that we beautify this area, but and part of it's in Commissioner Chapman's district and my district, and both of us could do a lot to help, but they've chosen to go a different route, so that's up to them.
Okay, what's the board's wishes?
Motion to approve?
I'm sorry, come forward. State your name for the record.
Thank you, Commissioners. I'm Lee Moore with Howard Group. Also live at 173 Grayling Way in Inlet Beach. And just wanted to clarify, we have not chosen not to get your help, Commissioner Meadows, and I apologize that we haven't had a meeting that you were able to attend and gave you late notice at the last meeting. We have not met again as a committee since that last meeting. We will hopefully be meeting soon, but we haven't set another meeting. You will certainly be invited, and I can provide a meeting in the interim if so desired. But we are so early in the process, still gathering information and still trying to get all of the stakeholders into our committee. I just spoke with the Inlet Beach Neighborhood Association this morning on the way to the meeting. So, it's from a time standpoint, pulling that many people together takes some time, but we're into that process. And also still, we don't have a lot to talk about yet because we don't know the estimated cost of the project. We don't even know the cost of a quote to get a cost for the project. So we're trying to do some preliminary work so that when we come to we have more information to give you, and we have more specifics about what it is that we need. So we certainly would love the help of the board as we proceed through this process, and we do understand that the county, unless, as Mr. Jones said, otherwise, unless something different comes up, does not have the appetite for maintaining these types of projects going forward. So we are also looking at that. That's another issue that we need to address as far as how that maintenance ongoing would be funded in the future. And as Mr. Jones said, we are looking into the possibility of applying for grants. So we're really just trying to do some preliminary work at this point. We hope to have another meeting soon. And if you all want more information on an individual basis, I'm happy to provide that as well. But at this point, we were just trying to get more of the facts and information around the project pulled together.
Okay. Might be a good place to look at using xeriscaping. Yeah.
Mm-hmm. Yes. We looked at that at the other end when we did that. So,
Yeah.
And we're also very interested in using as much native landscape material as we can. And so the environmental side of it is very high on the priority list. Absolutely.
Any other questions? Thank you, Ms. Moore.
Thank you.
What's the board's wishes?
I made a motion to approve.
You made a motion, got a motion?
I'll second it.
Got a motion and a second. All in favor, say aye.
Aye.
Opposed?
Mr. Chairman, it brought to mind that we had previously also given staff direction to work with the Beaver Lake Dam community on their DEP permit. I would ask, can we get the county administrator at the next board meeting just to give us an update on where that stands with regards to the permitting?
Sure.
What we've done. Thank you.
Certainly.
Okay, go ahead, Mr. Jones.
Next item, Mr. Chairman, is the request is for the board to approve us to go out for construction bids for the widening and resurfacing of County Road 183 south from south of I-10 to State Road 81. This is a SCOP program that the board agreed in April of last year that if the funding was approved, that we would move this project forward. And the county has received those funds and ready to move forward at this time.
Motion to approve?
We've got a motion and a second. All in favor, say aye. Aye. Opposed? Motion carries.
Next item was the South Lake Properties right-of-way agreement that we removed from the agenda. Next, we're requesting to allow bids to be to go out for bids to replant the trees at the landfill. You may recall that in January of last year, the board approved to have that timber harvested and to set aside funds in excess of $200,000 for the replanting. I'm sorry.
Just one.
Gasoline.
Gasoline.
Saw the puzzled look in everyone's eyes.
All right, what do you want to do, Mr. Jones, cover that one or continue on?
We'll do the gasoline.
All right.
We did a bid, an RFP for fuel services to the county. Mansfield Oil Company was the lowest responsive bidder, so we recommend that we award the primary contract to Mansfield Oil. And I will say that at the next meeting, we're going to ask for the approval of a backup or secondary source in case there's an issue here that either we can't get delivery or some other reason. It'll give us a secondary means of supply. But today's request is that you approve Mansfield Oil as the successful low bidder. And,
Where are they located? Where are they out of?
I'm not sure. You know where's Mansfield? Do we know?
Georgia?
Gainesville. Okay. Okay, thank you. Second.
Got a motion and second. All in favor, say aye.
Aye.
Motion carries.
Thank you. Now to the trees. As I mentioned, in January of last year, the board approved to harvest the timber at the landfill site and set aside any funds in excess of $200,000 to replant that facility. The total received from those that harvested timber was $335,911. So it's the board's or the staff's request that you approve to go out for bids to replant it, not to exceed the $135,911, which was in excess of the $200,000 threshold you set it in January last year.
So move.
Second.
Motion and second. All in favor, say aye.
Aye.
Motion carries.
Next item, Mr. Chairman, is in regards to the Local Restore Act, or the Walton County Comprehensive Plan for the Restore Act. We began this process back in the summer. We brought a draft to the board for your tentative approval, which we received. We took that document and presented it to the Local Restore Act Committee for their comments. Those were presented to you at the last board meeting. So today we're asking for your approval with those changes or any changes or amendments to those changes that you would like. From a staff position, we have reviewed them and find them acceptable. But any of them you would like to have discussed or make further changes to, we'd be happy to entertain.
I've looked at them, and of course, I've been working with this for a long time. I think it's a very good document. Of course, it's a fluid document. We adopt it today, and depending on what Treasury does and BP does, it will be constantly moving. But I do think it's a good document, and I'll make the motion to approve it.
Second, and I'll add that the committee has been working really hard on this, and yeah, this is a good document.
Okay, we have a motion and a second.
Just for clarity, the motion is to accept their changes and
Yes, sir.
incorporate them into the final
Yes, sir.
document. Okay, thank you.
Got a motion and a second. All in favor, say aye.
Aye.
Opposed, motion carries.
Will this document be placed on our website under Restore? Okay.
Chairman, the next item is regarding the resolution to amend the civil citation fees. I'm going to ask Mr. Dice to come and address that with the board.
Mr. Chairman, as we have discussed before, this item is really just to correct some issues that we had in the original adoption of this. As you may recall, it was done about a year or so ago. When that was done, the numbering was deficient, and how it was numbered did not match some things in the ordinance, and this is to correct that. And also, we've included some second and third penalties, some fees for those. You see an increased fee for the second and third offense, and that's the basis of this item.
And Mr. Chairman, Ms. Nielsen certainly raised some valid points, and staff would be more than happy to do some review of those and bring back any further information the board would like.
Well, I was going to comment concerning her comments that she made about it. As y'all well know, as far as how I feel about how to gain compliance of violations. And until you really hit somebody hard in their pocketbook, you're not going to really get compliance. It's just like whenever we were working on the proposed noise ordinance. That was one thing that I advocated as far as those discussions, is that first time you get hammered pretty hard financially. Second time, you get a trip to the county jail. So I'm thinking, and like Ms. Nielsen out there, that we need to really put some strength into these things here to make sure that it's not just part of doing business, they accept it for whatever.
Is part of this Florida statute, I mean, I think I've raised this issue before, and I certainly agree with Ms. Nielsen. $100 fine for most of these people is what they usually spend on lunch, I guess. If we do not hit them hard enough, then there again, it's cost of doing business. Are we governed by any statute or anything that limits us on the amount of fine we can levy?
Nothing I'm aware of, Commissioner. I would defer to Mr. Davis on that. I'm not aware of anything. I will tell you the initial fines that in here have not been changed since it was initially adopted last year. We would be glad to go back and try to do some analysis of maybe some neighboring counties and what their fines are for certain offenses. We'd be glad to do that and bring it back to you. That may be helpful as well. I'm not quite frankly, I'm not sure how these fines it was done by admin the last time, and I'm not sure exactly where they derive those fine amounts from.
Okay.
But I'd be glad to get with the folks who are involved and also look at surrounding counties and see how that works out. And in the meantime, also work with Mr. Davis on any kind of statutory limitations that may be in the Florida statutes.
Well, I agree with that too, but we also got to look at the enforcement side of it. We can have all this written up, don't mean nothing if you haven't got somebody out there asking for compliance to get them involved. So when you look at it and come back, I would suggest you come back with an enforcement plan too as to how this is going to be addressed.
Sure.
And also the third element of that, how much have we, levied in the past, and how much have we collected?
Right.
I know there's a whole bunch of money out there on the books, and there again, if we can't collect it. But do we need to adopt this today just for the numbering situation, or can we delay this?
Commissioner, I would suggest that if we could adopt this today, then we could bring back more and we can amend the actual fees. This is something we've been waiting on for quite some time to get this adjusted. But again,
how long do you think it'll take you to bring us back the fees? A month?
Yes, ma'am. Probably just do some research and kind of and discuss this with Mark. A month should be plenty of time to do that.
Yeah, just had to see road to everything. She's got the right idea. I will make the motion that we approve this today with the caveat that you bring us back within a month another fee schedule, comparing it to the counties, in the Panhandle as well as downstate,
okay,
and how we can enforce it and how we can collect the fees. That's my motion.
Second.
You got a motion, second. You have any further comments?
Just real quickly, we have some final orders that the Code Board has adopted. When it comes to collecting those, we really don't have a mechanism in place for the code enforcement staff to collect those outside of when something sells and they come in to pay the fees. If we have an outstanding case, I believe, and Mark, correct me if I'm wrong, I believe the code enforcement staff cannot do a foreclosure notice or anything like that, I believe.
No, we would have to foreclose the code enforcement lien, and many times that's not practical because you're foreclosing it subject to a first mortgage. So we're looking at all of them, frankly, see if there's any we can collect that way.
Hire a bill collector.
And let me point out too, I think Alex has done a pretty
The other places do it, yeah.
pretty big study on what's out there and what's been collected on these other civil citations. So that information is fairly readily available.
Yeah, we'll have that information anytime you need it.
Okay. All right, any other discussion? Have a motion and a second. All in favor, say aye.
Aye.
Aye. Opposed? Motion carries. Mr. Bagby.
Morning, Mr. Chairman, Commissioners. We have two bids. We request that you authorize to approve those. The first one is for our research services to Kerr and Downs out of Tallahassee. The bidding, there were two bidders, one out of Missouri and Kerr Downs, and the one out of Missouri, there was some concern about their financial solvency. They were the highest rated, but they were only higher by 1 point. So we ask that you approve Kerr Downs.
So moved.
Second.
A motion second. All in favor, say aye.
Aye.
Aye. Opposed? Motion carries.
And then we'd like for you to approve the bid for the repainting of the exterior of the TDC restrooms down at the regional beach accesses in the amount of $26,595.
So moved.
Second.
Motion and second. All in favor, say aye. Aye. Opposed? Motion carries.
On our updates, Mr. Chairman, we'd like for you to make an appointment of a commissioner to the TDC screening committee that's tentatively set to meet on March 6th.
Okay. Well, is that my call altogether? Ms. Meadows, what do you think about that?
I'll be glad to do that.
Okay.
Thank you.
We don't
Okay.
need a motion, do we do?
So move.
Second.
A motion and a second. All in favor, say aye.
Aye.
And
Motion carries.
while we're on TDC appointments, you should be either in receipt of a letter or receiving a letter from the South Walton Mosquito Control District. They have appointed, based on your guidance of changing the TDC selection process, their appointee is going to be Commissioner Tim Morris from the South Walton Mosquito Control District. And again, they will send you a formal letter since you've left that up to those two districts. I want to take a moment just to introduce our new Director of Administration, Sharon Santuri, who we've brought with us today. I will get her around to each of you to introduce her to you, and we look forward to her helping us, particularly in the financial arena. And then the last update is each of you will be contacted probably within the next week and ask for some time for a one-on-one interview for the TDC strategic planning process. And I would ask that you help us out and give us your input, give the facilitator that we've hired to give your input on the future direction of the Tourist Development Council. And subject to your questions, that's all I have, Commissioners.
Thank you.
Any questions? Okay, Ms. Santuri, you want to make any comments?
Mr. Chairman, Commissioners, I'd like to tell you all how happy I am to be here working for you and for the TDC. I believe that my experience will add a lot to the TDC. I have an undergraduate degree in accounting with public accounting experience, and I have a master's in public administration, and I was previously the director of administration for the First Judicial Circuit, and most recently I was a district representative for U.S. Congressman Jeff Miller. But I'm really glad to be here, and will certainly work hard and do my best to make you all proud of the TDC. Thank you.
Okay.
Thank you.
You're welcome. Mr. Davis?
I don't have anything scheduled, first of all, but I want to thank you for approving my contract today. And we will have, thank you very much. We will have the noise ordinance circulated to you in the next week and a half. The proposed ordinance, which we're trying to get down to less than 3 pages.
Wow, that would be nice, wouldn't it?
Okay, Ms. Meadows.
Yeah, I do have two things that I didn't put on the agenda. But the first one is that, and Larry, we may want to, I just want to get the board's opinion on this. You know, we talked about the 395-38 intersection. It won't be done, obviously, by this spring break or this summer. And so we talked about, with the sheriff, putting a off-duty, I think, policeman out to manage traffic at that intersection various times. Saturdays, check in and check out during the summer, spring break, various times, and Memorial Day weekend, 4th of July, and Labor Day weekend. And he sent us some cost, and since spring break is coming up, I think that, we need to probably go ahead and look at this. I think the costs are $25 an hour during the summer, $600 during the holidays, and spring break would be $1,800. So
An hour?
$2,400. No, total. Yeah, total. Yeah, no, total. And then the Saturdays was $25 an hour because they didn't really know exactly how long they wanted to be out there. So I don't know how we want to handle this, but since spring break's coming up March 8th and our next meeting's not until March 11th, what do y'all want to do?
Tell me the total
Sheriff,
again, because I kind of passed out when you said.
Oh, okay. Yeah. He has on here off-duty policemen during the summer would be $25 an hour, and that would be on Saturdays, check in and check out, when most of the stuff's going on. Spring break would be $1,800. That would be 9 days at $200 a day. 4th of July, Memorial Day, and Labor Day would be 3 days at $200 a day, would be $600 a day. So $2,400 plus $25 an hour during the Saturday check-in and check-out times.
Sheriff.
Is that
Good morning.
correct?
Just to, Mr. Commissioner, or Mr. Chair, Commissioners, actually another option came up when I was thinking about it, and I don't know how amenable you would be to doing this. Certainly, we'll try and cover any we can without going into any kind of detail. The problem we run into, if it is overtime or a staffing issue, I have to pay them overtime, which is more than $25 an hour for the most part. What would be the Commission's thought on we use the Sheriff's Posse quite a bit, and they do a lot of parking enforcement, and we've sent them to a certain level of training to do that. They're covered under my insurance or our insurance from that part. If we're talking about just that $395 and $30A, would that be something that you would be amenable to, or would that be something where we could also do an agreement for possibly if it's secondary employment, even for your code enforcement or something like that? We don't have any problem doing it, but I'm just thinking of other maybe less expensive alternatives, and the Posse does really a great job for us.
Does the Posse have any kind of uniform?
Yes, ma'am, they do, and we furnish them a uniform. In fact, they have a checkout vehicle as well too with lights on it. So what I was thinking is possibly using those folks as a supplement so that we don't spend $3,000, if you will. But I'll do it either way, and I mean we will, just to be clear. Anytime the traffic backs up, we'll try and do that without.
You want to bring it back at them?
Well, why don't you approve that $2,400 proposal, which is not a lot?
Yeah.
And then if we can do something different, we'll have that as the backup. If we
because
utilize the Posse.
Because that's spring break and the holidays,
Yeah.
so that's
Spring break starts this weekend.
yeah.
Bill.
Since this is specifically related to an influx of tourists, is this something that the TDC can cover?
No, so it'd have to be tied to some potential advertising in the future, and I don't think we could do that on this short-term basis.
Even though it is specifically for the tourists coming in?
Yes, sir.
And it's a convenience issue, not necessarily you don't think it meets that criteria. Either way, I mean, I'm just looking for different alternatives because I think one thing we're trying to move forward with from a vacation standpoint
with
is
something that to see how it works. So yeah, I would move that we would go with the spring break plan and the holiday plan, which would amount to around $2,400 plus or minus.
I'll second that for discussion. Is there
Okay.
any other area that we have trouble, especially during spring break? I'm thinking off of Scenic Highway 90, old Highway. You know what I'm trying to say.
Golf Drive.
That's what, yes.
Scenic Golf Drive.
Yeah.
Starts at Bruce Avenue and ends
Yeah.
at Highway.
Yes, that's true. It does
we
start at Bruce Avenue and ends at 98. But is there, while we're doing this for spring break, Sheriff, is there somewhere else where a deputy being there could deter, and you and I have talked in the last couple of weeks about the hordes that go on that beach and, take their beer and bottles and beer cans and all this kind of stuff. Is there somewhere else that perhaps some money wisely spent with a deputy there would deter some of the things that went on last year?
Yeah, I think they have a plan.
Yeah, we're pretty. I think at some point for us it becomes just purely a staffing issue. I mean, we could throw all the money in the world at it. At some point, we just have to be able to get. But that's why I was asking if you're amenable to the idea. I mean, certainly you can't just go out and hire all new staff for a short period of time, but if you're amenable to the idea of let's training up these part-time posse or volunteers, and they could help us with parking enforcement, they already do, but in the future, I mean, I'll do everything I can to cover any intersection that gets.
And I know
to that point.
you and I had discussed that, but I'm saying, if funding is needed,
Right.
to me, it's better to fund it on the front end and try to get a handle on it than let it get totally out of control. And then, so if you need extra posse or whatever
Right,
there,
right.
then I would throw that one in the mix too.
Okay.
Commissioner Meadows, if you're amenable to, if they need it.
I think that, I don't know if you've met with the sheriff or not for their spring break preparedness plans, but it's, it sounds like they've got a
money
really
to
good.
cover it right
sounds
now?
like they've got a good plan on how they're going to address different areas. But I mean, we could always come back.
Well, and call, I mean, as you're out in the community during that time, as you see it, call it in and say, listen, we're backing up here. Because a lot of times what we try and do is go and take control of the lights with the light switchers or send somebody for a brief period of time to bleed it off. So anyone that gets to be a problem too, just pick it up and say, listen, we're having an abnormal delay or it's a safety issue, and then we'll try and run somebody down there to do it. The biggest issue is just that. It gets to be, there's so many intersections that we run into that, that somebody has to be at.
And two, we can be out on the lookout this time for those intersections, and maybe we add some.
You're right. And that may change. That may change honestly from season to season too. So.
Okay. Oh well, my second. I go
Was
with you.
yours also the posse looking at?
Yeah.
Okay with that?
If,
We didn't state that. I
Yeah.
just
Unless
wanna make
it's
sure.
some local person they know, and then they just, wheeze on by them. I mean, they go, hey, there's Frank out there.
Hey, Frank. Yeah.
Right.
That green uniform does a lot, because I think as you're, driving, so.
If I could just have them as a fail-safe, just in case.
Yeah,
we don't have
I would
anything
keep their
else.
hat low, so.
As a bad.
Okay.
Yeah, sunglasses, hat.
Right. Gotcha.
Okay, we have a motion and a second. Any other comments, Sheriff?
Sir.
Okay, thank you.
All in favor, say aye.
Aye.
Aye. Opposed? Motion carries.
The second thing I have was kind of brought to my attention at kind of a later date, so I couldn't put it on the agenda. But it's been brought to my attention that when we did the E2 change for Osprey Point, I thought we were voting on only an E2 change. And it's come to my attention that a minor development order was issued for Osprey Point after that hearing. Now, I don't know what y'all thought, but the only thing that I thought that was advertised and that we discussed and voted on was an E2 change, a change in the acreage. Well, now, come to find out that we have actually issued them a development permit under a minor development order out of the planning department. And so I think that we need to take a look at this, because I'm not sure that, I don't know if y'all understood what we were doing, but to me it was very confusing, and we probably need to rescind that minor development order based on the fact that it was not advertised as that, it wasn't discussed as that, and our comp plan says specifically if it's over 20 units, it's a major development plan. So even though this plan, as people say, had been, kind of mulling around, it still didn't sit right with me that I thought what we were, because I would have said something, I thought what we were approving was only an acreage change, not a development order.
Okay. Mr. Osborne, state your name for the record.
For the record, Alan Osborne. I'd like to address by referring to the minutes of January 14th, 2014. That's when Osprey Point came up. I attended the meeting but did not speak. Greg Stewart presented a change to the DRI as an E2 change for a correction in acreage. I have no objections that there was a correction in acreage needed, and that this is the proper way to correct the acreage. However, at that meeting, it was presented by Mr. Stewart in the minutes, quote, that this request is not an approval that authorizes development. This is a cleanup provision which is required by the Technical Review Committee prior to moving forward. It is located off Heron Walk Drive. Both county staff and legal staff have found this amendment to be consistent with Chapter 380 of the Florida statutes, the Comprehensive Plan, and the Land Development Code. As Ms. Meadows pointed out, it is not consistent as a minor development with the Land Development Code. They go on to state that it was not advertised properly, so Mr. Davis asked that it be re-advertised, and there was a motion to do so. Motion by Commissioner Commander and second by Commissioner Meadows to continue Osprey Point E2 change to January 28th and to advertise it as an ordinance adoption. Attorney Stewart questioned the ability to properly advertise a public hearing. And Attorney Davis, Commissioner Commander, questioned if the compliance hearing needed to be held before the 28th. Attorney Davis stated it would be best to have the hearing prior to January 28th. Attorney Dana Matthews, representative for the applicant Sandestin Development LLC, requested an entire day be set aside for a compliance hearing. Attorney Davis stated he was aware that all representatives from all the parties would be present at this meeting and felt there was appropriate time to give notice of a compliance hearing. Discussion continued on the notification of the compliance hearing. Gary Vorbeck, representative of the Sandestin Owners Association, felt that a compliance hearing should be held prior to the adoption of the E2 change. Commissioner Commander questioned if the E2 change was correct as Scribner's error. Attorney Davis stated yes, and the E2 change could be granted. But if a non-compliance determination is made, DOs and permits cannot be issued. The E2 change does not give Sandestin Development the right to build at Osprey Point. Compliance must be met. Attorney Vorbeck expressed concern with approving the E2 change prior to the compliance hearing. Attorney Matthews suggested that the E2 change be held on January 28th and that the developer agrees, this is under a quasi-judicial hearing, that no DOs will be issued until a compliance determination is made at the compliance hearing. It goes on to stay, and they talk about the scheduling of the compliance hearing. I won't bore you with that. It then goes on to stay, Attorney Vorbeck expressed concerns that the E2 change ordinance being adopted and DOs being issued thereafter the 28th. Attorney Davis stated that if the E2 change would be heard on January 28th, 2014. If it is adopted, there will be no DOs issued for Sandestin until the compliance hearings are complete. He stated the compliance hearings will be set for February 3rd. Attorney Matthews clarified his position that no DOs would be issued on Osprey Point. Attorney Davis asked if there were any pending DOs. Attorney Matthews stated there were none. So I left that meeting with an assurance that we were just going to do an E2 change for a correction of a parcel, which I was okay with, and thought it to be a Scribner's error also. But that there would be no permits issued until compliance was met. Ms. Commander specifically asked about it, and it was discussed in depth. I left that meeting and said there being no further items to discuss. The meeting adjourned at 5:38. The next meeting was duly noticed on the 28th. I felt the need not to speak because all the items had been addressed to me by Mr. Vorbeck and had been addressed to the board by Mr. Stewart, Mr. Davis, and Mr. Matthews, that no development orders would be issued until compliance was met. The E2 change occurred, except that there also in the E2 change a discussion came up about postponing the compliance hearing, and the applicant requested a 90-day extension. He had already agreed that he wouldn't get his development order until the compliance hearing, and he did so in a sworn hearing. The E2 change went through, which I have no objections to, but the discussion that followed was a request to continue the compliance hearing. Me and some other people who've prepared objections to that had already prepared for the February 3rd meeting that was duly noticed. The compliance hearing was then kicked 90 days down the road, and the public hearing was over. There was nothing on the agenda from either the applicant or one of the respondents requesting that a continuation of the compliance hearing was going to be heard that day. How was I supposed to know when only an E2 change was noticed?
Mr. Osborne, please wrap up your comments, please.
I since have learned that the permits were issued right after the E2 change, and they were issued basis on the recommendation that a policy and procedure existed. I called Renee Bradley, asked to see the policy and procedure. It's nowhere in writing. So I guess as a homeowner, I'm supposed to figure out that I have to follow the land development code, but there's procedures and policies out there that are unwritten. We don't know who authority that they were issued on. I can't read them and know the left and right limits of them. And they've never been before the board. That would be a policy that is a deviation from the land development code and would need the board's authority. I would ask you to, you've already issued the development orders, but I'd ask you to stop the issue of permits, just like the meeting and the sworn testimony said, until the compliance hearing is heard.
Okay, Mr. Davis, you have any comments concerning that?
Let me go backwards a little bit. After I talked to Mr. Osborne and Mr. Heath at some length yesterday, it's apparent to me that an hour for the compliance hearing is just simply not going to be enough. Even if the Sandestin Owners Association and the Sandestin developer deal with their issues between them, there's going to be other objectors, most likely including Mr. Heath and Mr. Osborne and possibly some other folks. And those objections may end up being fairly lengthy. So what I'm going to ask the board to do in response and to accommodate that those objectors is to reschedule that compliance hearing to a time either before around that date or right after that date that we have currently scheduled, because there's no way we can do it an hour, and that will be wasting. We'll go in for an hour, we won't get a third of it or a tenth of it done. So my suggestion is even if the Owners Association, we set it for an hour with under the contingency that they would have an agreement, but that's just not going to. Even if that happens, we're not going to have sufficient time to hear all the other possible objections. So I would like for you to entertain a motion to reschedule it for a day certain for another all day. I would start at 9 and set it for 9 to 5. Frankly, I think it's going to take that long.
Wait.
That we can accomplish today.
When did we set it? Was it in May?
I'm sorry, I didn't.
When?
I thought it was May.
It was May.
Yeah, May 15th, I believe. Whatever the second. Actually, it was up here, and we probably need to do it down there as well. So.
That would be the third, and I don't have it on my calendar in May. The third Thursday is the 15th. And you want to do it all day long?
Yes.
I think so. I think that's the only way to.
And where would it be?
Down at the annex.
At the annex.
May 15th?
Do we need to make a motion to that effect? Or?
Please, yes, ma'am.
Commissioners, that meets your schedule?
Yeah, that works.
Yeah,
Commissioners, meet your schedule?
Yeah.
Okay. I'll make the motion that we hold the compliance hearing on May the 15th, starting at 9 a.m. At the South Walton Annex to continue all day. Do we have to set an ending time or just until we're through?
I would say 9 to 5, and then if
9 to 5.
Go beyond that.
My theory is if they can't be done in 4 hours, beyond that.
I'm just trying to anticipate how much longer they're going to need, but yes, ma'am.
And in that, maybe we should give each of the people or the parties a certain, you get an hour or you get 30 minutes or something, so that, everybody has a chance,
Commissioners,
an equal chance.
What I propose to you is allow me to meet with the folks I think are going to be interested and come up with essentially a pretrial agreement saying, you go first, you go second, you go third, and then there's rebuttal or something along those lines.
Keep it to this. You can argue for an hour.
Yes, ma'am.
Yes.
I think you could.
Pretrial it.
Case in an hour, I would think. Yeah. So, I think if we drag it on all day long, we're going to get people jumping up and coming up, and it just turns into chaos. So if you have an hour.
And again, it's a quasi-judicial meeting, and we have to allow for public input. But my suggestion is, if you'll allow me, I'll try to come up with a pre-hearing agreement with each of the major parties that I know are going to be involved, and then we'll set aside some time within the hearing itself for public input, and we'll limit that to an hour.
Okay, didn't we have some discussions earlier on that if we would take each topic or each alleged violation one at a time and rule accordingly? before
Yes,
you
we
go?
did, and thinking about it, that's probably going to be the easiest way. But my worry is we get one topic and we get 50 comments on one topic. We'll only finish one topic. So let me talk to the three folks
Topic
that I
per
know
day.
are going to be involved, and let's see if we can come up with essentially a pretrial order, a pre-hearing agreement.
Okay, do we need a
And-
motion?
And is there any way that we could have an agenda before the meeting that says, this is what we'll be dealing with, so that we can be kind of prepared?
That would be the goal of the pretrial agreement. I keep saying pretrial, the pre-hearing agreement, yes.
I'd love to have at least a week beforehand, if at all possible.
Yes, ma'am. I understand.
Mr. Davis.
Yes, ma'am. And I think you have a motion.
Yeah, we motioned, she seconded, yes.
Okay, we have a motion and a second. All in favor, say aye.
Aye.
Opposed? Motion carries.
Yes, would you address the unwritten,
Chairman, before you continue, for the record, I'd like to note that I abstained because of a business conflict.
Understood.
Provide lunch. Provide lunch.
Do traffic control.
What else you need there, Mr. Osborne?
will you address the issue of the permits on unwritten policy, and would you address the developer's agreement in the minutes not to receive his permits until compliance? I think compliance is a requirement.
Let me do I have Mr. Stewart here. Let me do the second one first.
I'm sorry, repeat those two back to me.
The first one was issuing a building permit for us. There's a development order. There's been no building permits issued, I don't believe. And he's asking, can we hold off issuing any building permits until the compliance hearing? The second thing was how it happened that there was, that the Osprey Point minor development order got issued.
Okay.
Mr. Stewart's here.
Mr. Chairman, Greg Stewart, Neighbors Giblin Nickerson, Tallahassee, representing staff. Back several years ago, there was a court case involving Walton County, and that was called the President's Counsel case versus Walton County. And one of the issues in that case dealt with the ability of the planning director to determine the administrative process that a particular application within a DRI would follow. And the court determined at that time, the growth management director, as Ms. Blackshear, had determined that all development approvals within the DRI would be treated as minor development approvals. The reason she did that is that there was a master approval of the DRI, and then that was the board approval, and everything else would be a minor. That was upheld by the court, went up to appeal to the first district. That was upheld again. When we began working with staff, we felt that that policy, which was subject to interpretation by the planning director, was really not an appropriate policy. And we recommended to staff that they change that process. And so since that point in time, a determination has been made by Mr. Dice that developments within a DRI will be handled under the process as any other development within the Land Development Code. So if it would be a major development outside of a DRI, it would be a major development within a DRI. But because we had several development approval processes where applications have already been filed, it was my opinion that it would be unfair and arbitrary for us to change that process in midstream. And so Osprey Point was one that was in fact on a minor development process under the prior interpretation of Ms. Blackshear. Now, Mr. Osborne's correct in terms of what happened on the 14th, in terms of the E2, and the E2 was the Scribners. On the 28th, the Owners Association and Sandestin had been mediating their disputes, and they came to this board and had resolved and had come to an agreement that they wanted to extend the compliance hearing for 90 days so they could continue to work it out. In exchange for that, the Owners Association would withdraw any objection to the approval of Osprey Point. And there was one other application, which is a chapel, which was in process, and that is still being reviewed by staff. But at the 28th meeting, as part of this extension, we discussed not only the approval of the E2, but also the fact that by this settlement, if it's in this agreement of the parties, that would allow that DO to be issued on Osprey Point. And that was the basis That was the basis that the planning department issued the DO.
And let me jump in here. The problem with that is, number one, we don't have the authority, nobody has the authority to strike an agreement with the homeowners association just because they say they're not going to, they're not going to fight Osprey Point. Nobody has that authority to say, oh, you're not going to fight it, oh, well, then we can approve it. Number two is that this development, Osprey Point, went to a TRC meeting, and they were told in 2013 that it was a major development. Now, they've been fighting that ever since. In my opinion, I feel like it was slipped in under the confusion of the E2 and all this, well, we're going to settle now, we're going to go back and settle, and, we don't have to have this big hearing. You left out the public, and you left out some of the other parties who were a party to this transaction, people who actually live in Sandestin, maybe not as a homeowners association. So I feel like that, this was maybe a decision made maybe by the attorneys or maybe behind the scenes that, okay, well, let's just let them go through. I never understood that in the hearing. I never would have allowed that because we were very specific in saying no more development approvals until you do the compliance hearing. That's what I understood, and it was very specific. I never understood that you were going to go back, and if the Homeowners Association of Sandestin didn't approve it, well, then wasn't going to fight it. Well, then, let's just let it fly. I feel like we've been kind of bamboozled and kind of a behind-the-scenes type thing, and I just don't feel, I just feel bamboozled by the whole thing. And so, I think that we ought to stick with our guns in the fact that we said no more DOs issued in a DRI unless they come through as a major development. And because this has already been issued, I think all codes and all proper due process, because it wasn't advertised. We didn't discuss it as a development order. We didn't see any plans for it. We saw a little acreage switch. So I just feel like that at this point, the development should be held up until further discussion has occurred and that this compliance hearing is done and that the board actually votes on approving this development. We have no idea what's in the development. We have no idea, and it's going. I just don't think that's right.
If I may, what was brought to the board by the parties was that there had been an agreement that no development orders would be issued at the January 14th meeting. And at this meeting, to extend this 90 days to allow the parties to try to work through the process, part of what they were asking for at that time was that the permit, the stay on the permit, which was a minor development approval process, Osprey Point, would be allowed to go forward, so that would not be held up the 90 days. And so that was an issue that I raised with the board.
That was never voted on. A motion was never made to that effect, and that was never, that was not advertised. It was an E2 change, and that is not a development order. And so, I feel like that it was slipped in there into the confusion of all of this stuff, and that's where my problem is I feel like we've been hoodwinked.
Just one comment, or maybe two comments. One, that's what you said is true in terms of not voting on it, but typically you wouldn't vote on a minor development order being issued. I understand the difference that you're making, but normally that's the case. What I would suggest, and I would defer to Mr. Stewart on this, is let me get with the developer and see if we can either get them to agree to hold off on the development order or applying for any building permits until the compliance agreement, or put on the next agenda that you might want to consider holding off issuing any building permits until the compliance hearing is done, and then that way nothing will actually happen until the compliance hearing is done.
I think if you ask them, obviously they're going to say, no.
They may tell me no, but at least
I think that, it's up to the board to decide what needs to happen.
Yes.
And in my opinion, I think, we should just say, hold off on anything else until we get, until they're in compliance. Because there is a compliance issue of residential acreage. And so this slides through that, this is part and parcel of the compliance hearing is the residential acreage.
To avoid the obvious lawsuit I see coming, can I suggest that we put it on the agenda for the next meeting to give the developer notice that we are considering doing that at the next meeting? That way.
That's what I was about to say.
We can't be accused of that.
Since it wasn't on the agenda.
But I think we ought to advertise it as such.
Yes,
I agree with Commissioner Meadows up to, but I don't think anybody's trying to hoodwink us or whatever. But we did say in the first meeting, we did lay down some rules that we wanted followed, and I think we deviated some from that. I don't think anybody was trying to, pull the wool over. And what is helpful is, Mr. Osborne had the minutes from that meeting. If we're going to another meeting, and Dee Dee did it in one of these that we did today, she had the minutes from the previous meeting so we can see who said what. And instances like that, it would be so great if we had that in our packet so we could go back and look at it. I know that's a lot of trouble, or references where we can, go on the website at so-and-so. Just remind us to go back and look at what we said. I think would be really helpful.
Okay. All right, Commissioner Meadows, is that fine as far as just directing this be put on the agenda?
Yeah, I think we ought to put it on March 11th, and I guess they've gotten a DO. What other permits would they have to come in with?
Obviously, they have to go with building permits, and Wayne, you might be in a better position to answer that than I am, but I know they'll have to apply for a building permit at some point.
That's correct. The next logical step would be the building permit. I'm not aware if they have or haven't. I've not heard about it, so my assumption is they probably haven't. But again, I'm not for certain that they have the status of that.
Okay, thank you.
Yeah.
Any other questions?
Well, what happens between now and then? They go build a building permit. I think that's why.
I will speak with Mr. Bearden.
Okay.
All right. Thank you. All right. Anything else, Ms. Meadows?
No, that's all I have. Thank you.
Thank you. Commissioner Commander.
No, sir. My Nigerian friends, one or two of them were in the legislature and couldn't get out, but they will be coming back for another visit. And I hope to bring them back to the board because I've met some of these gentlemen, and they are an interesting group. So
Okay.
that's all I have.
Commissioner Enfield? Commissioner Pridgeon?
Nothing.
And I have nothing. Is there any other public comments? Seeing none? We're going to take about 10 minutes before we move into the rest of the agenda.
For some strange reason, I put it on YouTube when I did that.
Is he here?
Did you want to see about the Rayco machine? Like 4 years ago, I did an interview about the Rayco machine.
We can do it right before we start. Yeah, can we just wait right before we close it? Just get you up here. Where?
I do too. Oh, I do too all the time. Yeah. Help me. I'm trapped in
The other day where somebody was trapped somewhere.
Observe or see that we had another public comment. Sir, if you'll come forward, identify yourself.
Thank you for this opportunity to address the commission. My name is Herbert J. Carter. I'm from Tallahassee, Florida. I've been in the entertainment business since 1958. I'm a writing, singing guitar picker. And my reason for being here is to introduce a concept of music called Dixiephonic music. The reason being that no one has identified our music in Florida, Georgia, and Alabama. And to put that in perspective, consider Cajun music comes from Louisiana, Texas swing comes from Texas, hillbillies, the origin of hillbilly music is from the Ozarks, bluegrass is from Kentucky, folk and Appalachian music identifies with the mountain people as they play their music. So I feel like that this will, I worked out of Nashville 10 years, and I noticed if you came from these districts that you already had a platform to build a career on. And we've never had one down here, and I feel like this will provide county by county musicians in any given county a platform to start a career and consider becoming professional. So that's my reason for being here. And the immediate plans is to develop a tour up and down US 90 and connect with US 98 in Mobile and continue to the East Coast and network in between and ask it be recognized through proclamations to provide this platform for aspiring musicians and writers and singers, and to keep this within time boundaries. That's about all that I have to say.
Won't this have to be put on the agenda if we're going to vote on it? Can we do that under public comment?
Sid, I don't see Mark.
It would probably not hurt to do that, but I think you could, by unanimous consent, move it to the next board agenda.
Mr. Chairman, this was previously on an agenda, and I went to Amazon.com where you can listen, pull up music and list it. When I click on yours, there's no samples. I have no idea what your music sounds like. And I'd be interested. I mean, to not have heard, and I realize I'm from the golden oldies era.
Right.
So I'm listening, and I assume that's not what this genre is. By the same token, there are some rapper music that people love that I wouldn't want to be associated with because of what's there. Is there a way we can get a sample of this before we?
That's a possibility and a probability. I can assure you it's not rap.
Is there a website to go to where if you click on it, you can hear some of your music?
I think there is. I had a MySpace in the past that there was little pieces of the music there. But I'm uncertain now. My website is not down. I can't turn the computer on. I don't have the knowledge to do that. And I currently don't have anybody to operate my computer system.
Well, if you find out that there is a way that we could perhaps get a peek, I mean, I'm certainly supportive of our songwriters and everything else like that, but to get behind a particular genre which currently doesn't exist and not knowing what it could be, I want to hear it.
If you have a CD, we can make a copy of it and I'll supply it to you.
Okay. Could I do that immediately after the meeting here?
Except Dee
Okay.
On the thin clients, you can't play a CD.
The guidelines that I've set for Dixie Phonics, and this is not written in stone, but song selection, my opinion, is a good song is a good song. And don't try to copy anybody else's presentation of the music. What you'll be hearing on my CD is original stuff, and it's a variety of music that represents culture. The document you'll read there identifies Dixie Phonics not only as a musical concept, but also a cultural exchange. So my plan is to, I'm also a writer, to search out the culture of any given county and suggest that the people that write songs start there so that it's a good foundation builder for your particular culture in your county.
Okay. Well, if you can get that CD to Miss Dee Dee, then we can have an opportunity to look at it and listen to it, and then
yes, sir.
Go from there.
I'll select, I won't do a complicated thing, but I'll select what I feel like is appropriate for y'all.
We don't need 3 or 4 hours, just a nice representation of it.
Thank you. If I could have the services of your duplicator, I'll do that immediately after the meeting.
Fine. Thank you.
Yes, sir.
All right. Mr. Dyes.
Thank you, Mr. Chairman. We have several items on the agenda. The first item is a legislative item. It's amendments to Chapter 2 of the Land Development Code, and I'll ask Tim Brown to come up and give a brief presentation on what these changes are.
Good morning. Tim Brown with Planning and Development. What this ordinance does is bring the Land Development Code and the Comprehensive Plan into compliance in terms of land uses. When the ear-based amendments were adopted in 2011, the code wasn't subsequently amended. So That's what we're doing now. We're amending it and making them consistent.
Any questions? What's the board's wishes?
This is the adoption hearing, by the way.
Motion to approve?
Second.
A motion and a second. All in favor, say aye. Aye.
Aye.
Opposed, motion carries.
Mr. Chairman, the next items are quasi-judicial, something that's to be sworn in.
Anyone who anticipates testifying on any item advertised on the quasi-judicial agenda, would you please stand and raise your right hand? Wow. Do you solemnly swear or affirm that testimony you're about to give before this board will be the truth?
I do.
If any commissioner had any ex parte contacts regarding any item on the quasi-judicial?
No.
Hearing none, is there any objection to the published notice is there any objection to the published notice? Any objection to it being added as an exhibit to each of the hearings? Okay. Mr. Chairman, I would suggest opening the public hearing and then for all the items.
Entertain a motion to open public hearing.
So moved.
Second.
A motion second. All in favor say aye. Aye. Opposed, motion carries.
Mr. Chairman, the first item is Peach Creek Phase 2A plat. This is a request to continue by the applicant due to their failure to obtain the signatures for the plat. We recommend it be continued until the March 11, 2014 board meeting.
Is this the one that we had discussed being the last continuance?
It is. This has been on the agenda a couple times. They still have not received a single one particular signature, and we've informed them this is the last time. Next time it'll be taken off.
So moved.
Second.
Motion and a second. All in favor say aye.
Aye.
Motion carries.
Next item is Alice Beach Phase 2A-U replat. This is basically they're replatting 5 existing lots. It's a small alteration in the configuration. We request a approval.
Any questions?
Any public comment?
Is there any public comment?
Motion to approve.
Second.
A motion and a second. All in favor say aye.
Aye.
Opposed, motion carries.
Mr. Chairman, the last item on the agenda is the Walton County County Road 385 30A abandonment request. We've got a request from the county attorney to continue this until the March 25th, 2014 board meeting.
Yeah, yes, Commissioners, we've had a couple of problems. One's a transmittal issue between Mr. Vorbeck and I in terms of getting this agreement finally signed and delivered. We also have had some issues raised by regional utilities regarding removal and how the contract reads in terms of moving and having easements for the utilities in these particular easements. So we're not ready. I didn't want to move forward to the abandonment called for in the agreement until we had a signed agreement.
Have we addressed the issue of the walls being a
Yes,
comp
ma'am.
plan change? And
And I got to bring that language back to you. Yes, ma'am.
okay.
Mr. Dice, someone told me that they wouldn't have to move the utilities because I had spoken to Mr. Wilson about that, and somebody somewhere
I'm not
somewhere
aware
out
of the-
there told me they weren't going to have to move the utility lines.
We're looking. Mr. Douglas,
Okay.
we're with regional utilities now, and I've been
Yeah.
talking.
Major utility pole
Yeah.
right in the middle of where the turn lane is.
I think, of course, Dewey's more concerned about the water line, whether they're going to have to be moved. Yeah.
And there's those as well.
And yeah.
Motion to continue.
So seconded.
A motion and a second. All in favor say aye.
Aye.
Motion carries.
That concludes our items, Mr. Chairman.
That, any other items to discuss? Staff okay with everything? All right, we stand adjourned.
Okay. Mr.